So good afternoon. May I welcome everyone to the 17th meeting in 2020 of the Delegated Powers and Law Reform Committee. We have apologies today from our members Mary Fee, Gordon Lyndhurst and Gil Patterson. The first item on our agenda is Declaration of Interest. Brian Whittle has joined the committee today, and in accordance with Section 3 of the Code of Conduct, I invite Brian Whittle to declare any interest relevant to the remit of the committee.
Nothing to declare, Convener.
Thank you. The second item of business is to propose that the committee takes item 5 in private, as this involves consideration of a future report, and this will be published when agreed. Does the committee agree to take item 5 in private? Thank you. Under agenda item 3, we are considering an instrument subject to the made affirmative procedure. No points have been raised on the release of prisoners, coronavirus, Scotland Regulations 2020, SSI 2020-138. Is the committee content with this instrument? Thank you. Under agenda item 4, we are considering instruments that are subject to negative procedure. Criminal Justice Miscellaneous Temporary Modifications Coronavirus Scotland Regulations 2020, SSI 2020-137. This instrument makes modifications to several acts to make provision for victims to be notified in the event of an offender's early release from prison when they have been released under the Coronavirus Scotland Act 2020. The instrument was laid before the Parliament on 4th of May 2020 and came into force immediately. This does not respect the requirement that at least 28 days should elapse between the laying of an instrument which is subject to the negative procedure and the coming into force of that instrument. The committee is therefore required, under standing orders, to draw the instrument to the attention of the Parliament under reporting ground J for failing to comply with the requirements of section 28.2 of the Interpretation and Legislative Reform Scotland Act 2010. Does the committee therefore wish to draw this instrument to the attention of the Parliament under reporting ground J? Thank you. The committee also considers the reasons for the breach of the 28-day rule, which in this case are set out in a letter to the presiding officer dated 4 May 2020. The letter explains that the Scottish Government breached the 28-day rule in order to bring the instrument into force on the same day as the release of prisoners, Coronavirus Scotland Act Regulations 2020. Had this not been done, there would have been a period of time when prisoners could have been released, but Scottish ministers would have been unable to provide information to victims about an offender's release. Is the committee content with the reasons given for the failure to comply with section 28.2? Thank you. Homeless Persons Unsuitable Accommodation Scotland Amendment Order 2020, SSI 2020-139. This instrument amends the Homeless Persons Unsuitable Accommodation Scotland Order 2014 to extend its application to all homeless people rather than only pregnant women and families with children. It also makes other changes to the circumstances when accommodation will be unsuitable. In addition, the instrument temporarily modifies the 2014 order until 30 September 2020 in response to the coronavirus pandemic to allow for temporary accommodation to be provided in hotels and bed and breakfasts. This applies where homeless persons need to self-isolate or otherwise comply with physical distancing guidelines. The instrument was laid before the Parliament on 5 May 2020 and came into force the following day. This does not respect the requirement that at least 28 days should elapse between the laying of an instrument which is subject to the negative procedure and the coming into force of that instrument. As with the previous instrument, the committee is therefore required to draw the instrument to the attention of the Parliament for breaching the 28-day rule. Does the committee therefore wish to draw the instrument to the attention of the Parliament under reporting ground J? Thank you. The reasons for the breach of the 28-day rule in this case are set out in a letter to the presiding officer dated 5 May 2020. In this letter, the Scottish Government explains that it considers this breach necessary to put in place the correct structure to aid recovery from coronavirus, providing local authorities with clarity on how they should plan their exit strategies and support a restructure of how we deal with homelessness. This is to ensure that all homeless households are able to be provided with high-quality temporary accommodation prior to moving to a permanent settled home. This instrument contains both permanent changes to the 2014 order and temporary modifications to those changes in response to coronavirus. Does the committee therefore wish to invite the lead committee to consider whether the breach of the 28-day rule is justified in policy terms, particularly in relation to the permanent changes? Great, thank you. The instrument refers to the Homeless Persons Unsuitable Accommodation Order Scotland 2014, when it should refer to the Homeless Persons Unsuitable Accommodation Scotland Order 2014. Article 3.1 also incorrectly refers to the modifications in this paragraph instead of the modifications contained in paragraphs 2 and 3 of Article 3. Does the committee wish to draw these errors to the attention of the lead committee under the general reporting ground? Okay, thank you. The instrument includes the words short period of time, congregate, large scale, small scale, and good standard. Does the committee wish to write to the lead committee inviting it to consider the Scottish Government's response in relation to questions on the meaning of these terms and whether it is content as a matter of policy to leave the interpretation of these words to the judgment of the local authority, having regard to any guidance issued by ministers, rather than provide a more specific definition in the order? Okay, thank you. I now move the meeting into private.